Excellencies, distinguished participants, please take your seat. As we normally do, I would like to invite, first of all, the Dean of the Faculty of Political Science, Professor Tungsupvattana, to provide some opening remarks, welcome remarks. This is Dr. Ajahn Ek's first major engagement after recovering from an operation. So welcome back, Ajahn.
Good morning and welcome to ISIS Public Forum on the 2017 Constitution and its organic laws in view the government's roadmap towards a return to democratic rule. From the outset, I would like to thank our reliable sponsor and partner, the Frederick Naumann Foundation, which we have worked and with fruitfully over the past several years. For putting together this forum, I also want to thank the National Democratic Institute or NDI for its support. As we know, 3 years have gone by since Thailand last and 13 successful coup in 85 years. I think it is fair to say that how many people felt about the coup then and how they feel now are different. For critics of the coup, this interim period has been too long and too costly for Thailand in terms of human rights and basic freedoms, and also in terms of economic management and international opinion. Even for some coup supporters, this long interim is becoming unacceptable. So one way or another, it does appear that the coup period is untenable and will have to lead to some political change with elections and return to popular rule before long. To do so, we have a new constitution drafted in 2017 and promulgated just last April. This constitution is Thailand's third in 3 decades. I do not want to go into details of the strengths and weaknesses of the constitution, but suffice it to say that it is controversial for its fundamental principle and its contents. But never mind, even with this constitution, many Thais are looking for its implementation so that popular rule can be restored. To get there, it is necessary to have enabling legislation, the so-called organic laws. Once the organic laws are in place, then the election mechanisms can be put in motion. The timing for this looks to be the second half of next year, but I'm sure our speakers can shed a clear light on when the election is likely to take place. Beyond having an election, Thailand will still have many challenges and political adversity, but I think we have to move ahead one step at a time. To help us grasp and understand the constitutional mechanisms and organic laws as well as the election roadmap, we have a top distinguished lineup of speakers today, comprising main political parties, the National Reform Steering Assembly, the Constitution Drafting Committee, and foreign experts. Please let me thank to them one by one. His Excellency Mr. Kasit Piromya, former Minister of Foreign Affairs, chairman of the subcommittee of political reform and the National Reform Steering Assembly. His Excellency Mr. Chaturon Chaisang, former Minister of Education and former Deputy Leader of Pheu Thai Party. His Excellency Mr. Norachit Sinhaseni, former Permanent Secretary of the Ministry of Foreign Affairs and Spokesman of the Constitution Drafting Committee. We also got Mr. Ivan Doherty, Senior Associate and Director of the Political Party Program, the National Democratic Institute for International Affairs, or NDI, Washington, D.C., and Mr. Marcus Loening, former Human Rights Commissioner for the German government, Member of Parliament. This forum is intended to be informative, constructive, and inclusive. Please feel free to raise questions and comments at the appropriate time, but please keep them to the point and constructive. I hope you will enjoy the proceedings, and many thanks for joining this forum.
Okay, but may I please invite the speakers to the stage and take your position, take your place. In the meantime, as you've heard from the deans, the numbers are the reality that we have. 13 successful coups in 85 years. This is the third constitution in 3 decades. And in Thailand, sometimes we are superstitious. So the numbers they end with 7. So in 1997 we had a constitution, and then we had a coup in 2006. Then we had a 2007. 1997, following a crisis, we had 1997 constitution, led eventually to crisis, and then coup in 2006. So we had a 2007 constitution, led eventually to crisis, and another coup. So we had a 2017 constitution. So 3 constitutions, 3 decades. I'm not sure if these numbers are auspicious, but they're a cause for some superstition among some Thais. 13 coups and successful. If you don't count all the unsuccessful as well, it's 19 coups or coup attempts in 85 years. So this is a number, the numbers that we are trying to work with and avoid repeating. We have 5 speakers. We have limited time. The first speaker will be Kun Kasit, former, I'm sorry, Tan Ramtri will be the third, but the first will be His Excellency, former Ambassador and Permanent Secretary of Foreign Affairs, Norachit Sinhaseni. He has been a member and a spokesperson of the Constitution Drafting Commission, and he'll be followed by Chaturon Chaisang of the Pheu Thai Party, and then His Excellency Kasit Piromya. Ambassador Norachit has to leave early because he has engagement with the Council of State. So for 15-20 minutes, Ambassador Norachit, can you tell us an update? Give us an update on not just an update, but also the trend, prospects of the so-called organic laws or enabling legislation that would allow the election to take place. Up to 10, I think we have enabling laws, but do we need all 10 to be in place before we have an election? And when do you think the election will take place? The floor is yours.
ขอบคุณครับ Professor Titinan, thank you, and good morning, สวัสดีครับ It's a pleasure to be with you again. Excellencies, I didn't anticipate the interest at this amount, but it's heartening to know that our friends are still interested in the proceedings here in Thailand. Let me just cut to the chase. As Professor Dr. Ek had mentioned, we will not be discussing the pros and cons, the positive, negative effects of the Constitution because it is in place. let us proceed to where we are now, where we're going, and try to answer the question that Professor Titinan just posed to us. If we can indicate or give a indication on when the elections will be held. Let me just say that I'm not a spokesperson for the government nor the NCPO. Elections will be held when they deem appropriate. As a representative of the Constitution Drafting Committee, I can tell you, according to the Constitution that is in place, when we will need to complete specific tasks, and that I mean the 10 organic laws that has been stipulated in the Constitution, that these 10 organic laws have to be in place before the elections can be held. It doesn't necessarily specify that, but by all intent and purposes, 4 organic laws are required before the elections can be held. The first organic law, and this I refer specifically to Section 267, that the Constitution Drafting Committee, led by Kun Michai, shall continue to perform its duties, and in completing the preparations for the following draft organic bills. And the 4 that I mentioned are the Organic Act on Election Commissioners. In short, there will be its election of new commissioners. That was specified in the Constitution. What we had proposed was that those sitting commissioners that meets all the qualifications will continue to hold office. We submitted it to the National Legislative Assembly. They had another idea. They, in effect, rule that all the present sitting commissioners will vacate office and all new election commissioners will be elected. That's 7, an increase from 5 to 7. That's the first organic law. The second organic law is the one on political parties. These are the 2 that we felt are the priorities because, number 1, the National Election Commission has to prepare all the groundwork and will be supervising the elections. Number 2, the political parties themselves, there are things that they need to do under the new organic laws in terms of the seed money, in terms of collecting membership fees from members, preparing new election membership rolls, etc. The third is the Organic Act on the elections of members of the House of Representatives. It is basically the similar system where every Thai citizen of eligible age and qualifications elect their own members of House of Representatives from their own district, but rather than electing another indicating the political parties, the vote they cast for each candidate in the district counts towards the party list for each party. The last one is the Organic Act on the installation of senators. So these 4 acts have to be passed before the elections can be held. So where are we now? Number 1 is the first 2 acts that I have mentioned have already been submitted to the NLA. The first 2 were submitted simultaneously on the 18th of April. On the 21st of April, the NLA, in its first session or the first reading, had passed those 2 laws. And then ad hoc committee was set up, basically mostly NLA members, but 2 of our own members from the Constitution Drafting Commission also were included. They had completed their work, and the NLA passed the second and third reading of the first law on the election commission National Election Commission on the 9th of June. So in that respect, they have finished their work. What the Constitution specifies that once they have completed the draft, they are supposed to send that draft to the Constitution Drafting Commission, which is us, to the organic body responsible, that is the National Election Commission. We have 10 days to consider whether any of the provisions that have been approved contravene the Constitution. So by the 23rd of June, we will have to say either yes or no. And I don't think I'm disclosing any state secrets in saying that at this stage, we, the CDC, do not anticipate that we will be sending any objection to that draft act or bill. There is indication, according to the press, that the National Election Commission may be questioning the bill. That we have to wait until the 23rd of June to find out whether they do or not. Once they do that, in the case that they do, no better word than maybe as a protest, if they say it contravenes the Constitution, then an ad hoc committee comprising 5 members of the National Legislative Assembly, 5 members of the CDC, and 1 member from that particular organic body, which is independent body or the National Election Commission, will sit together for 15 days and come out with the final draft. It again goes back to the NLA. So that is the time frame we are looking at. I went into all these details for 2 reasons. Number one, to give you an indication of where we are now on the first 2 draft acts. And again, you can apply that to the end of December, which is the time that the CDC has. That means 240 days from the date that the Constitution was promulgated. That is the 6th of April, if you recall. So 240 days, or roughly 8 months from that time, we have to complete our work. And if you are interested in elections, that would be the worst case scenario. That means we submit 2 draft acts, or 1 or whatever, on the last possible date. If that is the case, then you can just use this time frame that I gave you as a template and just put it down on the calendar. That means if that 240 days fall on the 6th of December, for example, then you start the process of 60 days consideration by the NLA, and following the first session, second, third sitting, then again, those draft acts are submitted to us and the appropriate independent organs for them to consider for another 10 days. If they say there are provisions in there that contravenes the Constitution, then we meet for another 15 days. At the end of that period, the bill or the act goes to the Prime Minister. It goes through the process of printing and writing, and it is submitted to His Majesty the King. In the Constitution, His Majesty the King has 90 days to consider each and every act. Within 90 days, any time within that period, he will sign the bill or act if he agrees to it. It is then published in the Royal Gazette, and the elections have to be held within 150 days of these 4 bills being promulgated. I was told by people responsible that it is not your responsibility to be fixing any dates on when the elections will be held, so I'm sticking to that particular instructions, but using the template that I have tried to set as an example in the case of the first two acts. I think with that same template, you can project when the elections will be held. So to say probably at the end of 1962, of 2025-62 would be a good indication. 61, I'm sorry, next year. Yes, 18. So that is where we stand at the moment. You may be interested also that, as I had indicated, the first two draft acts have been submitted. We have 8 more to go. The third has also been submitted to the NLA, and that is the draft act on the criminal procedures for persons holding political positions. That had been submitted on the 12th of June. So again, the NLA has 60 days to consider that act. The fourth that has been submitted already was the organic act on the Ombudsman. That was submitted on the 15th of June. That was yesterday. So that is the fourth. The next to be submitted will be the organic act on the National Human Rights Commission. That will be submitted to the NLA on the 26th of June. Next on the cards would probably be the organic act on the state audit or the procedures of the Constitutional Court. Those would be the next two in line. And the last, I would believe, would be the organic act on anti-corruption. You will notice that I had omitted 2 important acts and did not give you any time frame on when they will be submitted. That is the important act on the elections of members of the House of Representatives and the act on the installation of senators. As I had indicated earlier, these 2 acts, in addition to the 2 on the political parties and the National Election Commission, will determine when the elections will be held. And I purposely did not mention these 2 because our chairman had indicated very clearly that it is not our intention to leave these 2 acts to the last. If they were to the last, then we will be looking at the scenario that we were discussing, that early December will be the time that these 2 acts are submitted to Parliament, to the NLA or to Parliament. He has indicated quite clearly that once the act on the political parties and the National Election Commissions are promulgated, they start the work immediately. They, I mean, the Election Commission will have to find new members, elect new members. The political parties will have to start their activities. So in that sense, we are answering another question that is on the minds of many. And when can we start political activities? When the political parties can meet, can hold their meetings, meet with their members, and conduct political activities. I'm not speaking again for the NCPO, but it is logical that these are the activities and what they need to do. How can you not allow them to start or begin conducting such activities? So that is a practical response and not one that I have been told or been authorized to present to you. But basically, if they are to be able to finish their whatever activities they need to do within the 6 months that has been specified, then it is logical that at that time all the suspension of political activities, particularly with regard to the political parties, will have to end. And I raise this again because many of the provisions that have been drafted means political parties will start having to preparing the new members list, preparing the seed money, finding ways to collect membership fees from their members. We had tried to specify how much time each political parties will have to conduct such activities based on what we felt would be the priority, what they need to do first, second, third, etc. When we met with them, they said, please give us adequate time. Don't be so strict. So what we did was all these specific time frames that were given were all, in general, changed to around 6 months. So whatever they need to do, they should complete it within 6 months. So from the time that the Act on Political Parties is promulgated along with the Election Commission, then it is a time of around 6 months. If either, or it should be both, if in both cases, political parties and the National Election Commission give us some indication that, look, what we have been told to do, we have completed the task, we are ready to hold elections, then my chairman said it is possible that the Act on the elections of members of House of Representatives and the installation of senators will be submitted. So it will not be the last 2 acts submitted. So in that case, that time frame, that template that I gave to you will have to be moved to either September, October, November, or whatever, and then you put that template down and work from there. So that, in a nutshell, is where we are in terms of the organic laws. Let me just take just a few more minutes to mention the what has been in the news on 3 specific issues. The first are the terms of office of the members of the independent bodies. A lot of attention was placed on the National Election Commission because, number 1, it was the first act that was presented. Number 2, there are quite a number of commissioners whose qualifications may come into question once we apply the new constitution. And it's a matter of fact that some were more vocal than others, so that is probably why you're seeing more reports in the papers. Some were just quietly letting the matter proceed and the cards will fall where they may. Some had come out and voiced their own opinions, so that is why there was such interest in the National Election Commission. What we had proposed was that now that the Constitution has been promulgated, we will look at the qualifications and the prohibitions of each member, coupled with the composition and the objectives of each independent body. In the case of the National Election Commission, we felt that, number 1, the qualifications definitely have to be at the standard of the new incoming commissioners. Otherwise, you would have 2 tiers of members. For instance, we are saying that any new member of any independent body cannot own or have shares in the press or the media. If we were allowed to those that are already incumbent to continue under the original qualifications, then some sometime in the future, there are possibilities that those that are new members are prevented from holding such shares or becoming owners of the press and media, but does not apply to the former members. That is just an example that we cited. But then NLA had different ideas. When we presented it to them, they said that based on the new composition and the structure of the National Election Commission, all members will have to vacate their offices. So that has been what you have been hearing and seeing in the Thai press for the last 2 weeks. There are now a lot of clamoring that, okay, now that you use this criteria, will you use it for all the remaining independent bodies? My chairman and the committee or the commission has made clear that that principle will remain. We will consider the qualifications and the prohibitions based on the new constitution and based on the structure. But this does not apply to one particular body, which is the National Human Rights Commission. You all know that when it was first formed in BE 25, 40 or 50, we were given very high grades as an example of what a National Human Rights Commission should be. In subsequent constitutions or laws, there were inclusion of more members from the government sector, from the judiciary, and as a result, one of the points that we were downgraded from a category A to B was that the selection process, the selection committee, and the members of the commission were not as varied, coming from various fields in society as it should be under the Paris Principle. So what we have done is we have strictly tried to follow the Paris Principle with regard to what we have written in the Constitution regarding the National Human Rights Commission. The elections, the qualifications, the selection committee is entirely different from the other independent bodies. So in that particular case, there may be other considerations. So in short, we are still within the time frame specified for us that we are supposed to complete 10 organic laws within 240 days or roughly 8 months. The idea was to consider and submit one draft organic law per month. I think we are ahead of schedule because from April, May, June, end of June, we have already submitted 5, so more than around roughly half, and the remaining draft acts, one per month, should not be something that is not surmountable. So I hope that I have given you a clear indication of where we are now with regard to the 10 organic laws, give you not a clear indication of when the elections will be held, but a rough template that you can put down in your calendar once all the laws, the 10 organic laws, have been promulgated. The most important date to remember is that once the 4 laws on elections have been promulgated, the National Election Commission has to conduct the elections and complete the elections within 150 days. Thank you very much.
ครับท่านทูตนรชิต he has to go early, so I think that we will take just a quick round. If you have any questions at this time, But just to recap, so 240 days since April 6th, there have to be 10 organic laws, enabling laws in place. And of the 10... Submitted. Of the 10, 4 are indispensable, necessary for an election to take place. Those are the Election Commission Act, the political parties, and then the MPs, and then the senators. These are the details that have to, the requirements that they have to be in place. Now, what if you exceed the 240 days? Is that possible? From this time frame, so all things being equal, we would have by December 6th, 10 organic laws, right? Submitted. And then I think His Majesty the King would have up to 90 days to sign. So all things being equal, let's say up to March 6th. And then 150 days for the election to take place. This takes us to August 6th. So all things being equal, it will be in August. That's the earliest possible date. Let me ask you, Ambassador Norachit, what is the latest possible election date, if that's the earliest, August 2018?
Well, there are small details like I omitted the details on giving you the example of the first organic act. Basically, if you read the Constitution, you would think that, okay, now that the NLA has finished the second reading and third reading, and then you have 10 days to consider, another 15 days for the ad hoc committee. But the time doesn't start, because in the case of the first law, for instance, they finished their work on the NLA, I'm saying, finished their work on the 9th of June. They did not submit those laws to us until the 14th of June. So that took another, basically 6 days. We received it on the 14th. So those 10 days start from the 14th. So roughly on the 23rd of June, we have to give our reply. We are not anticipating that we will be objecting to anything, but there is a clear indication and a high possibility that the National Election Commission will object to certain provisions. If that is so, then you have to have the NLA meet again, I don't know when, to set up this particular ad hoc committee. So that, I omitted all that, not intentionally, but there is no way of me knowing or any of us knowing when the NLA will meet, and they say, okay, we'll set up this committee. They may select 5 of their members. We would be prepared to select 5 of our members. It depends on the National Election Commission how soon they can indicate who will represent them, for instance. But I think in this case, it would be the chairman of the NLA, of the National Election Commission. So as soon as that ad hoc committee is formed, then you have another 15 days. And then again, once they complete the work, it goes back to the NLA to consider again whether any changes have been made before it's submitted to the PM for royal approval by the king.
Okay.
So there's a small discrepancy there.
So the point of clarification here is that 240 days from April 6th, that date is for submissions,
For submissions.
not completion. So
Not
in
completion
fact,
of the whole.
entire process can really be pushed back until next year, and then eventually.
Well, I don't think it will go that far. Well, if we're talking about 240 days, it's roughly early December. Then you have 2 months, December, January. So early February is when the NLA has to complete their consideration. So that 60 days apply. And then again, probably around another month, I would say, another month. And that is when the last organic act passes consideration. It goes to His Majesty, then you have that 90 days.
I'm going to pose a little question, and I'm going to open up to the floor and also to our panelists for a quick round. This, Thai media call this vacating the offices as a set zero, which is a reset. Do you think that this effort, I mean, this prospect of a reset, replacing wholesale these various independent agencies, what are the motivations behind that reset option? That's just a quick question for me, and then to open up to the floor. There's one hand here.
Regarding the reset and the selections of the new elections commissioner as well as the members of the National Human Rights Commission, the question is, how can we be assured that the new member, the EC or the NHRC, will be more independent when the body that would have the final say in approving them to be the current NLA, if it's done before the election? Or if done after the election, it will be the NCPO overwhelmingly selected member of the upper house of the Senate. Thank you.
Okay. Any other questions about the reset? So this is a very fair question, Basan Norachit. I think there's a lot of public perceptions that the independent agencies now, if you replace all of them, a lot of people think that maybe the new individuals, the new officials would then be kind of handpicked by the regime, the incumbent regime, in order to control pre and post election processes. What do you say to that?
Well, let me answer your first question on the resetting of. I think there are two words used interchangeably in the Thai media. One is reset and set zero. My understanding of it is reset is to look at each individual, but set zero is a wholesale vacating of the entire body. So that is the first question. Number two, I'm not in a position to answer that as I should, because that is not what we propose. We propose merely that you look at the qualifications under the new constitution and the prohibitions, and you go from there. The change has been made by the NLA, so they are in the best position to answer that. And on public perception, let me say that in drafting the Constitution and the other organic laws, we have tried to listen to the people, maybe not as widely as people or certain quarters would like, but polls have been conducted. We went out to meet the people, and there are views also that set zero for all of them and start from the beginning. Those views are also there. To Kun Pravit's questions on how do we ensure, or how can we ensure that the new members of the independent bodies will be more independent, I think you do what you can. What we have done in the Constitution is, number one, every body, every new member, we have looked at the qualifications where we feel that they have specific tasks to do, like the new members of the National Election Commission. We added 2 new members, and these 2 new members are specifically tasked to look into irregularities and the election frauds. So they are members who should have experience in the legal field, and those are the qualifications we set out for the new members. So number one, we have tried to do so by setting higher standards, higher qualifications. To a certain extent, we are being ridiculed and saying, you will not find any applicants, or your standards are too high. And there will be no applicants for such bodies. We have some example. One is the National Audit Commission. That bill has not been passed, but there is the NCPO order saying the selection process has to begin. There are still around 2 weeks to go. There are, as I heard yesterday, 11 applicants already. So one of those concerns that have been raised, I think, is being answered by facts that yes, you have higher qualifications, but there are still people readily coming forward to apply for such positions. Number two, we have indicated in every law and in the Constitution that members of the independent bodies have to be independent, do not belong to any political parties, be courageous, act in a positive manner, and not just wait for people to come to them with complaints. I think that is about as far as we can go in writing the law. But again, you're saying that the selection process, those that will be selecting these people will be coming from the present setup, which is basically appointed. Or again, you were saying if those elections came after with the appointment of the senators who will come after the new constitution, then we're saying that those bodies responsible for electing will be held responsible by the public. What we're trying to do is make the selection process as transparent as possible. Number one, we will be requiring all these selection process to be voted in public. So they will be not public in the sense of public viewing, but those that are making the selection will have to make their selection choice known and to indicate in writing why they have made the selection, or in the case that they object to one member, why they have not. I think that is about as far as we can go. I don't think we can be reading the minds of any people, but like I was sitting in the, listening to the process of the NLA yesterday on approving the Political Parties Act. The debate went on for 6 hours, and we didn't get everything we wanted, and many of the views presented were looking at the practical purposes and the ability of the political parties to conduct their activities. So there were views on both sides, but at the end of the day, I'm sure the newspaper report today will say military appointed assembly approves organic law submitted by military appointed commission. I don't think we can do anything about that.
Thank you very much for your candid views, Ambassador Norachit.